This week, welcome to topic 2 and the second week of your exploration of what a contract is. This week we start our deep dive into each of the elements of a contract. So last week in the first topic, we started that exploration of what a contract is, how a contract or a legally enforceable contract is different perhaps from a standard agreement or from an agreement, a social agreement, an agreement between mates. How we recognise agreements generally, but that contracts are a subset of those. We didn't spend a lot of time, but we started this idea of the difference between a private and a public law. So this idea that a contract forms a private set of rules that two or more parties agree that each of them will abide by and get the benefits of others abiding by during the course of their dealings on a particular subject matter. So from here, we're going to move forward to start unpicking each of the elements. And you'll be able to recite these elements off by heart before too long. And the first of those elements is agreement. Now, when I went to uni, an agreement we actually referred to that as offer and acceptance. But these days, we have a broader understanding of agreement. And although the traditional approach is to identify the offer and see where it has been accepted, it is actually quite possible to have an agreement where it is not possible to identify both offer and acceptance. So in other words, we can see that there is consensus ad idem or consensus so that the parties themselves have reached an agreement. And we'll talk about that at the end of week 3, most likely. So here's my guide. Eventually, please move forward. Here's my overall-facing guide to what we're going to be doing over the next 2 weeks. There's quite a lot there. It might be a little bit overwhelming. In this recording, I'm going to get to the end of Carlill and Carbolic Smokeball. But before we really get stuck into the cases, I really want to have a quick chat about why it is that we need to do the deep dive. So it can be really quite confusing that we spend the first half of the semester looking at each of these elements, each of these jigsaw puzzle pieces, for want of a better expression, in really great detail, but we don't really look at the top of the box. So it can pay to reflect a little bit on why it matters to know so much about agreement or offer or acceptance or certainty or intention or whichever of the elements it is that we are exploring. And a key reason for that is ultimately the job of lawyers is to solve problems. And there are 2 kinds of problems that contract lawyers solve. We either want to work out how to write down the rules of the game, write down the terms of a deal in a way that will be binding and represent the intentions of our party, our client and the other parties, or something has gone wrong and we want to be able to identify whether there was a contract or not, and as a consequence whether our client can either enforce an obligation or is required to do something that they otherwise don't want to do. And when you think about it, most of the contract cases that we will look at in the first half of this semester are cases to do with the question, is there a contract or not? Kind of the easy win for us is to talk about or to think about in any of these questions that you will get as assessment tasks, really I'm being asked, is there a contract here or not? And when we think about that, there are quite likely many deals that go ahead every day that won't technically fall into the legal definition of contract, but even so, each of the parties does what they promise to do or receives what they promise to do. Some of them might grumble about it, but they don't question whether or not there was a contract. Here, most of the cases, we've got a party who either doesn't want to do something or wants to make sure somebody else does something that they believe that they should have done, and usually a combination of the two. That's led to a dispute that's led to a question in a court which in turn has led to a greater understanding for us on what a contract is. Once we know whether there is a contract or not, we might also be asking ourselves who can sue on that contract. That's something that we'll delve into in a little bit more detail when we get to privity. If there is no contract, we might also be exploring whether or not there's another way to enforce the promise. And you will see as we go forward that there are often other ways that things can be enforced. They might be enforced by statute, or equity itself might sit in. But we need to actually understand what kind of remedies might be available where there's a dispute and our client otherwise feels wronged. If there is a contract, we also need to identify what the terms of those contracts are and what it is that our client needs to do or what rights our client has, or sometimes both. And that in turn falls to that last point, that understanding what a contract is helps us understand the specific rights and obligations in each case. So to determine whether or not there is a contract, we need to determine whether or not all of the formation elements are present. And you'll be reciting these in your sleep before too long. We need to look for an agreement, consideration, intention, and certainty. So agreement is where our focus will be over the next 2 weeks. We'll primarily look at whether there's an offer or acceptance. In fact, we'll spend all of week 2 and some of week 3 just exploring offer. We will then look at acceptance. But really what the question is here is whether the parties have reached consensus and whether or not the acceptance of the deal, the acceptance of the offer has in fact been communicated back to the offeror. We'll follow on then and we'll spend 2 weeks examining consideration. For now, just think about that as to whether or not the parties have struck a bargain. And for want of a better word, think of consideration as price. It's the price that's paid for the promise. That's too simple, but it's confusing enough to get through offer and acceptance. So if you can just bear with me and trust me that if you think about it as price to start off with, we'll delve into it in some depth following on. Ultimately, too, we will need to explore whether or not the parties intend to have legal consequences when they enter into this agreement. Is this intended to be a legally enforceable contract, or is it just some other kind of set of promises? And ultimately, we'll also be exploring the extent to which the parties have clearly identified their rights and responsibilities. And to a certain extent, intention and certainty and consideration, we will touch on all of those to an extent as we explore what an offer is. Because by its nature, an offer needs to encompass the DNA of the deal. It needs to be capable of acceptance without variation, which means it needs to incorporate an intention to be bound. It needs to be certain, sufficiently certain at least, as to what the rights and the responsibilities of the parties will be when the offer is accepted. And it needs to incorporate consideration. It needs to demonstrate what it is that what the price is for the promises that are offered, so that when that is accepted, it is clear that the person who is accepting understands what price they need to pay or what promises they need to make in consideration of the content of the offer before a bargain can be made or a contract can be made. So as you work through each of these, I would strongly recommend that you keep asking yourselves those questions. What do we need to create the contract itself? And why, in this case or in this circumstance, do we need to know whether there's a contract at all? What turns on the question of whether there is a contract? Who cares and why? So to do that, I strongly recommend that you continue to use the IRAC model. Now, I'm a bit of a cheat. I tend to think about IRAC a little bit as the way I learned to do it, which was MIRAT. So as in, what are the material facts, M for material, what are the issues, what are the rules, how do they apply, and then instead of conclusion, using a tentative conclusion. So I tend to bundle up when I talk about this, identifying what the material facts are, because that's an important part of identifying what the issues are. The thing about the world is that the facts don't necessarily present themselves in the most material way. Many of you will have already done torts, many of you will be doing torts at the same time, and there will be a point at which you will have to do the PhD, the practical aspects in the JD, which includes an interviewing process. And when you think about what that interview is really all about, it is about, in many ways, identifying which facts are material in order for you to identify what the real issues are. So from there, you can identify what the rules are, apply those rules, and come up with some advice for your client. The interesting thing about IRAC is you sometimes have to move backwards and forwards, that you need to understand the rules well enough to be able to ask the questions in order to identify the material facts so that you can really hone in on the issues. Because some issues arise from the facts and some issues arise because of the way that the rules work. And it's only when you've done those things that you can apply them. So a good practice thing to do, and a great way of really keeping your notes and maintaining them, is as you're taking notes about the cases you read, you might like to use IRAC in order to organise those notes. If you keep a note about what the issues in each case were, what the relevant rules might have been, how those rules were applied, and the consequential conclusion, you'll find it much easier to sensibly read those notes as you go forward. So returning back, let's now dive straight into agreement. So the objectives in this topic over the next couple of weeks are to explore the legal nature of agreement and to examine specifically the rules relating to offer and acceptance. In addition to that, we're going to learn about the process by which agreements are formed, and we'll examine the statutory rules on electronic contracts. This is going to involve identifying the nature of agreements, examining the rules relating to offer and acceptance, and understanding the processes by which agreements are formed. I like to think of that by following this kind of basic flow chart, that what we will be doing here is basically identifying first when we need to do an offer and acceptance analysis. We start then by using an objective test to work out whether there is an offer, and which requires us to look at a range of different behaviours which look like offers, smell like offers, sound like offers, but might not be offers. So we'll explore some of the different options, including puffs, invitations to treat, etc. We'll need to, in this context, understand the difference between bilateral and unilateral contracts, because this helps us understand how, depending on how the contract or purported contract is classified, what the obligations of the parties are at which point. We need to understand at which point offers can be revoked or terminated, and what the consequence of a termination is. We then need to explore whether or not the offer has been accepted. So, spoiler alert, a contract is made at the time and in the place where it ripens, to use the words from Carlill and Carbolic Smokeball, when it ripens into a contract on acceptance being made. And so in order to do that, we need to explore the idea of what acceptance is and how that acceptance is communicated and when it doesn't need to be communicated. And then lastly, when we've got this issue between what, if there is a difference between what an offer is and how it's accepted, when is that a counter offer and in fact no deal at all, and when might it be evidence of consensus or a battle of the forms? So these are the things that we'll explore over the next couple of weeks. I'm going to use this basic definition of an agreement as we go forward. So classical contract theory states or purports that the offer and acceptance is essentially a formula to identify the magic moment of formation, the conception of a contract, if you will, when the parties are ad idem, so Latin for one mind, and their individual wills come together to create binding obligations. So a private law between the parties is formed in relation to the subject matter. In the moment when an offer is accepted, all of the parties' contractual obligations spring into existence. The formation of a contract requires this consensus ad idem, that Latin term that means a meeting of the minds. The meeting of the minds relates to the contract subject matter, and this is why certainty becomes such an important issue and demonstrates how certainty is very much related to this idea of offer. So an agreement, a legally enforceable agreement, is based on a voluntary assumption of rights and obligations. This idea that a party has entered into a private law where they have voluntarily adopted some or accepted some obligation in exchange for some corresponding rights. In determining whether an agreement has been reached, courts use an objective test. Taylor and Johnson is probably the best authority for that, being an Australian High Court decision, but Carlill and Carbolic, Smokeball, the extract that you have in the casebook, explores this idea really well, really usefully. So the objective test asks us to not consider what a person actually intended or meant by their conduct or otherwise, but what a reasonable person having the same information as the other party involved in the exchange would have understood by that assessment of the facts. Your secret mental reservations are ignored. So the traditional doctrine of agreement is based on an offer by one party and a correspondent acceptance by another. Often, however, in the real world, it's very difficult to apply this mathematical formula, and we need to really be alert. But in a nutshell, an offer added to an acceptance, or that has been accepted, will result in an agreement under common law. The offer itself needs to be clear and capable of acceptance on its terms. This is, as I keep saying, linked to certainty. And the acceptance needs to be communicated to the offeror without any variation or amendment. A variation in an acceptance or a conditional acceptance is in fact a counter offer. So we have those, we have agreement. So let's actually start drilling now down into what the offer itself is. And the objective here is to help you identify an offer out in the wild. So what is an offer? An offer is the indication by one person, and we call that person an offeror, to another person, the offeree, of their willingness to enter into a contract on certain terms. Notice this language. We see it often in legal language where we use or to be the person who gives something or does something, and the offeree to be the person who receives it. One of the things we see regularly is lay people confusing the idea of mortgagor and mortgagee, for example. You often think that you get a mortgage from the bank, but in fact you give a mortgage, which is a form of security, to a bank, and you are the mortgagor and the bank is the mortgagee. So offeror and offeree is good use of technical language here. So although an offer cannot in itself give rise to a contract, it creates in the offeree a power subsequently to create the contract by accepting the offer. Of course, they need to do that before the offer has been withdrawn or terminated, but if an offer has been addressed to them, it's capable of acceptance in its terms, and it hasn't been accepted yet, then it is the offeree who actually has the power to create the contract. And the contract is created when that acceptance is communicated. So what nature does an offer have? Courts employ an objective test in determining that. Carlill and Taylor and Johnson are good authorities for that. The actual intention that the offeror has is irrelevant. What is relevant is what the offeree, or what a reasonable person in the offeree's position would have understood by the conduct or the offer. The intention ascertained from the point of view of a reasonable person in an offeree's position is that reasonableness test. Offers can be made, by the way, to individuals, to a group or a class of people, or to the world at large. And an offer provides all the information that's required so that the terms can be identified when the offer is accepted. So the offer contains what I like to call the DNA of the deal. It needs to indicate whether it's only made to a specific person, to a specific class of people, or it can be accepted by anyone. It needs to communicate that the person who's making the offer intended to be bound by it, or it needs to be reasonable to infer from their words, actions, or writing that they intended to be bound. It needs to identify with some certainty what being bound means and what you will get in exchange for accepting. Exchange what you will get if you accept and what you will be required to give if you accept. So that's the price or the consideration. So I like this definition that you'll find in your casebook. I mean, it's flowery language and I wouldn't suggest that you use it, but I think it does contain all of the relevant elements of what an offer at common law is. An offer is the manifestation of willingness to enter into a bargain, so made as to justify another person in understanding that his assent to that bargain is invited and will conclude it. So an offer is an indication, a manifestation of a person's willingness or intention to be bound by some bargain or exchange. And it's made in a way so that a person who receives that offer understands that by accepting the offer, that they will not only receive the benefit of the promise that's been made, but it'll be clear as to what price will be paid for that, and that on giving assent or accepting the offer, the agreement will be concluded, as in it will be made, the agreement will be made. So let's explore that using the first case that comes up in your casebook, Gibson and Manchester City Council. So this is an appeal from the House of Lords from the 1970s. The facts all occurred in the early 1970s, and basically it involved a policy that happened at the time in Manchester, and the picture on the slide will show you what a Manchester council house looked like. So the Manchester City Council Corporation, I think it was, had a policy of selling council houses to the people who lived in it. And Mr. Gibson was one of the tenants in one of those council houses. And he applied to the council house, to the council, to get some details or information about what would be involved in buying a house from the council. And under that policy, the council would also advance funds, so they would lend the money and expect a mortgage in return, some sort of security for that. Let me just click on to the next slide, which might be hard to read depending on the device you're using. But this comes straight from the casebook, you'll recognise it. It's a copy of the letter that was sent by the council to Mr. Gibson. So the important parts are, it basically starts, it says council house, it says that they refer, oops, sorry, I flipped on when I didn't mean to, refer to your request for details of the cost of buying your council house. Interesting, your council house. It then says the corporation may be prepared to sell the house to you at a price, and then it basically discounts that price as well. It then provides a whole heap of financial information and ends with these words. If you'd like to make a formal application to buy a council house, please complete the enclosed application form and return it to me as soon as possible. So Mr. Gibson completed that application, and the form itself ended with the words, I now wish to purchase my council house. And he returned the application to the council in March 1971. However, before the formal contracts could be prepared, there were some elections in that local district, and the new council had a different policy. It didn't want to continue selling these council houses. It had a different political point of view. So it refused to process any unfinished applications, and Mr. Gibson's application was one of those. He argued that there was already a binding contract though, and he'd put in his forms, it should be processed, and he had the right to buy his house. So he argued that The letter that he received, which we had on the slide earlier, was the council's offer to sell, and by returning the application he had accepted it. So he argued that a binding contract had been formed. The issue before the court here was whether in the correspondence between the parties there can be found a legally enforceable contract for the sale of the house in which he resided. So note this. In all those elements that I spoke about at the beginning, in order to identify whether a contract exists, none of those is writing. We can make a contract, as I said last week, through our conduct, through our words. We can do it some in writing, all in writing, one document, many documents. There are some sorts of contracts that can only be enforced if there are formality requirements that are complied with, so that if there is a written instrument of some sort. But on the whole, we don't need to point to one document. And so he was arguing that objectively, a person in the position of the tenant would understand by the council's conduct, including the correspondence between the parties, that there was an offer, that they were making an offer, and that that offer was capable of acceptance. So the court then needed to apply the test to work out whether or not there was a contract. And ultimately, they applied a well-settled and elementary principle of English law. How unlike judges to sound somewhat condescending. So they applied what we refer to now as the conventional approach to ascertaining whether or not there was a contract. Firstly, they looked at a handful of documents, and these are the documents that had been relied on as constituting the contract by Mr. Gibson. And then they saw whether on their true construction, so their true meaning, a true understanding of what they meant, there was a contractual offer made by the council and there was acceptance made by Mr. Gibson. So what really the court looked at in arriving at that true construction were the words that I've highlighted on the slide. This is just a repeat of the letter that you saw earlier. In particular, they focused on this word here, may. The corporation may be prepared to sell the house to you. And then subsequently, if you want to apply another word, a synonym for offer to a certain extent, if you want to make an offer to buy your house, you can make the application on the form and then we'll consider it, is effectively what that meant. So ultimately, the court found that the correspondence from the council was no more than an invitation to treat. It was a statement of the terms on which the council would be prepared to consider selling the house, that there was no promise to sell. The conclusion that they drew was that the words may be prepared to sell, and if you would like to make a formal application in the letter, make it impossible to construe the letter as a contractual offer. The letter and the application form simply set out the financial terms on which the council may be prepared to consider a sale, and that would happen in due course. Accordingly, they found no contract. Too bad, so sad. So you might actually then stop and consider, is this a fair decision? That could be the kind of question that would come up in a critical analysis case. And I think these words from the judgment are really instructive on that point. Essentially, the judge is saying, this might look unfair, and if you have a political view that it is better for people to own their own houses and for councils to reduce what's on their balance sheet in that way, you might think this is an unfair decision and you might be tempted to construe the contract in another way. But the hard cases, even though they offer this strong temptation to find a way to get the result that you want, that is a temptation that needs to be resisted. In fact, his words are, it is a temptation that the judicial mind must be vigilant to resist. And the reason for this is, as we started to explore last week in topic 1, and we'll keep going back to it, is that there are benefits for a stable economy in having contractual rules that are enforced consistently. If commercial people can enter into commercial bargains, knowing what the consequences of those bargains will be and how they will be enforced, it is better for trade and commerce in the long run. And you'll see this is a theme that repeats itself regularly. So now we get to the seminal case, Carlill and Carbolic Smokeball. I often joke that this is the case, this and Donoghue and Stevenson are the two cases that every lawyer in the world, I think, well, every lawyer who's had any exposure to the common law will recognise and remember the facts of. So basically, well, let's explore it. So I thought you might be interested to see some copies of the commercial. This is Court of Appeal decision from an appeal from a decision that was made by Justice Hawkins. It's set out in your case book at 3.25. So it's an 1893 decision. I love looking at these ads. I find this absolutely fascinating. I'm particularly keen on understanding at some point what throat deafness is. To me, it reminds me of Zoolander and the black lung. You'll see these are, there are many different versions of the advertisement. Unfortunately, they're not great. So I love Mrs. Kingsley here, writes from the working village in Surrey in 1892. I have a very great hopes of being able to hear quite well by the end of the month. My whole throat was in a dreadful state. And when we consider I have been deaf since 1884, I think the improvements in the 2 months since I commenced using Carbolic Smokeball is wonderful. So this is the device. It looks a little bit like this. I always, until I saw the picture, sort of imagined as being kind of a Vicks fake rub thing, but it's a bit like snuff or something, I imagine. I'd love to see what it looks like in real life. So basically what the facts were here was that the Carbolic Smokeball Company, I'm going to refer to them as the defendants, issued an advertisement, we've seen a couple of them now, in a range of newspapers to promote the Smokeball product. In those advertisements, they offered to pay £100 to any person who contracted influenza after using it as prescribed. So £100, by the way, it is actually worth looking at how much money £100 is. It's a lot of money. It's basically, I've done a quick conversion. It's at today's money, it's worth a little over £12,000 or a little about 21,500 Australian dollars. So think about that. If somebody said to you, yes, sniff this little smoke ball twice a day for 2 weeks and you won't get the flu, but if you do, I'll give you $21,000. Would you think that was a promise? Or does it sort of sound a little bit like Red Bull gives you wings, or spray yourself with this deodorant and many, many women will come or men will come and want to kiss you? Think about those kind of advertising campaigns. And that's relevant because the Smokeball company did basically argue that it was a puff, that it wasn't a real promise and nobody would understand it as a promise. However, notwithstanding that, the advertisement also included these words. They stated that £1,000 would be deposited with the bank to show their sincerity in the matter. So Mrs. Carlill used the smoke ball in the correct way, but she got influenza and she sued the defendant for £1,000. Now, this actually also looks like a product liability or a misleading and deceptive conduct case these days. I think it would have been brought in a completely different way if the time had been different, but it wasn't, and this is a range of reasons for that, in particular where the state of contract and personal liability laws were at the time, and contract law was the way that the lawyers for Mrs. Carlill thought that she was best likely to get her best outcome. And it's quite likely that Mrs. Carlill was just a test case anyway, that there were probably many others, and I don't know this, but it's quite likely that there were many others who were in the same situation. Advertisement here, so those are the words that were used, and I've actually just realised that the word sincerity has dropped out on the slide. I'll fix that before I share them. So 100 quid reward will be paid by this company to any person who contracts the increasing epidemic of all of these terrible things after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied. So it's quite clear what they had to do. 1,000 quid, so 10 times the amount of the reward, is deposited with the bank, showing their sincerity in the matter. So the issue before the judge here was, or the judges, is whether there was an indication by one person to another of their willingness to enter into a contract with that person on certain terms. In other words, was this an offer, or was it an advertisement, or even a mere puff? So the Smokeball company argued that it wasn't an offer. The words were never intended to express a promise, and that they had no intention. It was just a mere puff or a boast, and was never intended to be legally binding. So, and they did this because part of the, in order to understand what an offer is, we need the offer to contain all of the DNA of the deal. So it needed to demonstrate intention, incorporate intention. And they're saying we never had intention in the first place. Then they argued that, well, even if you find against us there, and even if you find that we made an offer, then you can't find an agreement because Mrs. Carlill didn't communicate her acceptance of our offer. So in order for there to be an agreement, there needs to be an offer with a corresponding acceptance that is communicated to us. They then also argued that there was no consideration paid by Mrs. Carlill for the promise to pay 100 quid. She paid for the Smokeball, yes, but she didn't pay separate consideration for this separate promise, if in fact it was made. And then they argued lastly that any contract that was found would fail for uncertainty because the advertisement itself was too vague. For example, it didn't include a time limit for contracting the diseases or being able to claim the amount of money. Mrs. Carlill's lawyers, on the other hand, argued that it was clearly an offer to the public, and as a member of the public, Mrs. Carlill was able to respond to that offer. That as soon as she did what the advertisement directed, she did have a contract with Carbolic. In other words, she'd accepted the offer. And it was only when she fell ill with the flu that she was entitled to pay the £100 that the whole of the obligation, for want of another word, that was required to demonstrate acceptance of the offer was actually made. So ultimately the court held that you can make an offer to the entire world which will ripen into a contract when someone comes forward and has performed the condition. This happens when you have a unilateral offer, and I'm going to need to talk to you in a minute about what unilateral offers are and how unilateral offers differ from the offer that's made in a bilateral contract. Acceptance of a unilateral offer occurs by performing the condition, and so the acceptance actually occurred, in a word, when Mrs. Carlill got the flu. Notification of the acceptance can occur at the same time that she performed. So her performance and acceptance are tied up together in the unilateral contract idea. So let's talk a little bit more about unilateral contracts and bilateral contracts so that we have a better understanding of how that works in the Carlill and Carbolic Smokeball situation. So we have these two types of contracts. Actually, we have many, many types of contracts. There are many ways of classifying contracts, but for now I want to talk about classifying them by whether they're bilateral or unilateral. So a unilateral contract, which is the kind of contract that we saw in Carlill, we have two parties to the contract. Let's call them A and B. Only one promise is made by A. So, for example, A promises to pay $100 to B if B finds a lost puppy. B accepts the offer when they do the stipulated task. So it doesn't matter if they say, hey, yes, I'd love to do that, but then they never do anything. They're not in breach of contract because acceptance actually happens by doing the task. Similarly, it doesn't happen if they don't. It doesn't matter if they don't respond at all. They just go out, find the puppy, and bring it back. In the first case where they say yes, they'll do it, then they can't, but they do nothing. They can't complain that the other party has breached the contract because there is no contract. They haven't actually performed the act that constitutes acceptance. In the other case, where they just go out, find the puppy and bring it back, A can't argue you didn't communicate acceptance because acceptance is actually communicated by the doing of the act. So that's why it's called unilateral, because at any given point in time, only one party has an obligation. So the contract is made by accepting or performing the task that is the consideration for the promise that A makes. And so B, by finding the puppy, or Mrs. Carlill by taking the product in accordance with the directions and then contracting the flu, has performed the obligation that constitutes acceptance and has nothing more to do. And that the contract is made absolutely at the point where B has performed their obligations. And so when the contract is made, the only party who has an obligation is party A, or in the case of Carbolic, the Smokeball company. So I've tried to draw this out to try and demonstrate it in a way that I think will make sense. So in a unilateral contract, we have an offeror and they make an offer. At the point that they make the offer, they have no obligation at all until the conditions attached to acceptance have been met. And they can withdraw that offer at any time. The offeree, on the other hand, has absolutely no obligation to do anything when the offer is made, but if they do what the offeror asks, a contract is made at that point. The offeree could be anyone at all, or it could be a specific person, unless the offeror stipulates otherwise. So that specific person. And the thing that they need to do needs to be done prior to the offer being withdrawn. If the offer is withdrawn before performance is completed or commenced or completed, doesn't matter, no contract can be made. But once a unilateral contract is made, the offeror is bound to do the thing that they promised to do, and the offeree has rights to receive that benefit. Usually, the offeree has nothing more to do because they've performed their obligations as part of the process of accepting the offer. A bilateral contract, on the other hand, is actually simpler in real life but messier to draw. In a bilateral contract, we have an offeror who makes an offer. When that offer is accepted, the contract is formed. The offeror then has obligations which it needs to perform for the benefit of the offeree. And the offeree has some rights which it is receiving, being the same as the obligations that the offeror is giving. And those rights it gets in exchange for some obligations or some promise or some price that it pays to the offeror. So that's the first half of the class. We'll continue on with woolen mills in the next half. If you have any questions, concerns, consideration, compliments, frustrations, please share them with me directly. You have my email or text, or if you think others can benefit from them, and I'm sure they can, please share them on the discussion boards. All the best.